Namaskar, this is Seshadri, your labourlaw advisor, corporate trainer, posh IC member. Statutory compliance, December 2024. In this year, this is the last month. We have seen lot of compliances during 2024 and we are going to welcome 2025 also in December 2024. What are all the compliance? If we see, it is a very less compliance only this month. But a lot of judgment has come during November, that also we must understand. In this video we have this is the agenda. Compliance for December 2024, first part. Second part, December training as well as statutory updates November 2024. Please watch till end because lot of judgment has come, so we can see those judgment and it may be useful for as a knowledge for us and precaution for us. Let us share this video all HR fraternity so that the knowledge will be shared. Compliance part, if you see, it is very minimal compliance this month. As usual compliance under PF and ESI, we need to pay on or before 15th December 2024 for the 8 months November 2024. The first one is PF, another one is international workers monthly returns as well as ESI challan. These are all the main usual compliance we should do before 15th December 2024. Next, if you see, the major thing is national and festival holidays. We have to submit our national and festival holidays list to concerned authorities. Either it is a labor office or dish or factories inspectorate. Tamil Nadu, if you take rule 5 of 1, it suggests we have to submit on or before 31st December 2024. All the state also, because this National and Festival Holidays Act is done by all state governments, so each state will be having separate rule, but it is predominantly 4 national holidays. It is common for all the states as well as 5 holidays, that is festival holidays we can use. We would have taken Form 3 approval from the concerned authorities earlier itself. According to that, what are all the dates falling in 2025, you have to fill and submit on or before 31st December 2024, as well as we need to display a copy of that list in our notice board also for our employees. Part 2 is a training. We have 3 trainings, public programs we have this month. First one is on 12th December at Hotel Kalyan. Part 2A is FMEA control plan and SPCs. This very good program for all the engineers, particularly from the quality and new product development, as well as for HR. We have standing orders and domestic inquiry. Very essential program for all the HRs. We must understand standing orders because we can avoid all the disputes. Even if it disputes comes, how to do the domestic inquiry. That is a part of this session. This is a one-day workshop at Hotel Kalyan, Chennai. And another interesting program which is very successful in Chennai, Coimbatore, Trichy and Pondicherry. That is a major program is workshop on appointment, recruitment, probation, confirmation and termination. What are all the laws behind in these areas, as well as what are all the precautions we should take. This session is going to be held at Hotel Sri Krishna Palace, Hosur on 14th December. Please near the Hosur HRs, please come and participate. It is a very useful program, knowledge sharing session for you. And online session, as you know, on Sundays and as well as Thursdays, we will have online session. You can contact Mr. Dinesh for further bookings. Statutory updates, this is a part 3. If you see, there are huge updates are coming from EPFO. First one is employee, that is employment linked insurance, sorry, not insurance, it is incentive government is going to give, that is central government. What are all the incentives employer is going to get? What are all the incentives employees are going to get? The detailed video is available in this channel. Every HR as well as every entrepreneur, that is employer, must understand what you have to do. Educate employees to activate their UAN. All the employees must activate, particularly the employees who joined after 1st April 2024. That also, even if it is a first time employment, it is very essential to activate. As well as we need to understand, if you are a HR, please present what are all the incentive schemes available from the government. We present it that to management. The detailed video also available. If you require PPT, I can send you. As well as now we can check who are all the people, that is employees activated their UAN or not activated. There is a provision in our employer portal of PF. That details also available in this channel, how to check also. Next one is PM internship program that is already implemented, we know very well. Only thing doubt is the amount what we pay to the internship employees. We can't call them as employee, that is the students, whether that will comes under wages definition or not. So central government has given the clarification. Particularly, they are not entitled because they are coming for education. They are not entitled for wages, as well as that is whatever the payment is called as a internship allowance. It is not called as a wages under PF Act as well as Payment of Wages Act. That clarification central government has released. Next, if you say big breaking is EPFO. Because 30th November they have conducted a high level meeting. In that they have taken the many decisions, particularly for pensioners. They are going to give centralized pension. Already the trial basis, some 2-3 states they have tried. It is very successful. So all over India, pan India, pensioners will be, all the pensioners are going to get from centralized pension. As well as for employer side, few things are good things are that banks. Not only all the banks which are listed with RBI, we can use that one. That is the thing going to happen. As well as any employer, any default is that if voluntarily if we disclose, no penalty, no interest. That is also going to come. As well as employee side interest calculation. There is a chain. When you are taking the advance, at that time, that month they will not consider for the interest calculation. Now it will be converted into days basis interest calculation, so that it will be favorable for the employees. Next, if you see the each state, because National and Festival Holidays Act, it comes under state government. So many states they have given the list of holidays, what are all the holidays they are going to follow. Even though they are going to follow, we have to take the dates from that, whatever the government declared dates, that date we have to take. And that we have to substitute our holidays, that is 4 national holidays and 5 festival holidays. We have to substitute. We have to display in our notice board, as well as we have to send to the concerned authorities, either it is a labor office or dish office or factory inspector. We have to communicate. And CPI points, if we see Chennai is September 2024 is 336. It is reduced. And judgments, lot of judgments are there. Nearly 20 judgments, very good judgments. It is a knowledge. Please see till end. PF establishment, one establishment, they have PF authorities, they have done for the assessment, but we want to do more. They are not properly done, so we can demand. You can again you open like that. We can demand the assessment. There is a one. Letter of intent. When we hire the people, we give letter of intent. That is not a legal document. Earlier itself, many judgments are there. Now also same thing has happened in the last month judgment. It is not, there is no binding signature between the candidate and the management. So that is not a legal document. Next, if you come disciplinary, disciplinary proceedings can be initiated after employee retires. Employee retired. So you want to take any disciplinary action? It is not possible. That's what Supreme Court's judgment. Under posh, when the sexual harassment, one candidate is applying for the job. Anything happens to her under sexual harassment, whether the POSH Act will cover? No, it will not cover, because the POSH Act is only for working the place. There only it is going to cover. So the court has advised the government to please pause. That is feminist perspective point of view, you can enact the act. Next is employee compensation. Contractor and one subcontractor. In subcontractor employee something injured, who has to pay employee compensation? The judgment clearly says it is a responsibility of the contractor. Next is ESI. CA firms, lawyer firms, they will not come under ESI Act. Earlier also some judgments are there. Again same thing as given by court. Disciplinary part. The interim order, labor court cannot pass an interim order restraining the employer from imposing the punishment. Employer can give any punishment. So labor court will not come and interfere, restrain the, stop the punishment. Under POSH Act, like this judgment, even in Pune University case also same thing has come. The complaint was not served the respondent. When the one woman is giving complaint against the respondent, what is the actual complaint? It should be served to the respondent. It was not done. As well as witness was examined in the absence of respondent. So Kerala court has said, IC must observe the natural justice. Without natural justice, if you follow it, it will not be valid. That's what Kerala High Court passed that. And disciplinary part, No show cause notice for probationer. If you want to terminate, no show cause notice required. That is a Kerala's High Court judgment. Under PF dispute, so any dispute regarding the PF contribution, we cannot do arbitration because it is a act. What is the percentage you have to contribute? That's all. In this, arbitration is not possible. That is the Tripura High Court judgment. Compensation, employee compensation. When you take the policy from the insurance company, we cannot applicability. You cannot put the applicability. The Employees Compensation Act is not applicable. Not like that. It is applicable. That's a Madras High Court judgment. Under POSH, transfer. So one POSH complaint has come, the management transferred that employee. It is not valid unless ICC, that is internal committee, is recommending. You cannot do those things. So based on the internal committee's recommendation only, you can do transfer. You can't do on your own. That is the Madhya Pradesh High Court judgment. Another again under PF. Without finding one organization is that whether PF Act is applicable to that organization or not. Without finding that, they have passed the order for this much you have to pay, like that. It is illegal. That's why Madhya Pradesh High Court given the judgment. Para 26 of 6, under the Para 26 of 6 only we can contribute higher wages. That is, we can take higher wages and contribute to PF. That is a PF scheme. That cannot exercise. In that, there is no limit as given when you can exercise. That time limit has not given provided. Because a time limit not provided, you cannot ask after retirement, I want to contribute for under Para 26 of 6. That's what Kerala High Court, you cannot do. During the employment only you can do. Next is under discipline, misconduct, particularly theft. So when the theft has happened, no one can ask for sympathy and reduce the punishment. It is not possible. That is registered by Karnataka High Court. Employee employed through a contractor, the contract employee cannot seek permanent employment from the principal employer. That is Allahabad High Court's judgment. Transfer, very very important clause in your appointment letter, transfer clause, because that legally many things happen after future, so you have to be very careful while putting the transfer clause. It is very essential clause, also mandatory clause. Transfer is an incidental happening. So this actually speaking, this is an employer right. So the employee cannot, I am facing so much difficult, so you withdraw or you cannot challenge that transfer. That's what Madras High Court has given the judgment. Nomination under ESI, one husband has expired, wife as per document it is divorce, but they both are staying together, so they can be considered as a nominee. That's what Madras High Court has given. And ESI basic liability under ESI is immediate employer. That is, your contractor is there, contract employees, contractor is the sole is responsible. You cannot say principal employer is responsible. Even though principal employer can, in case if he fails, that the contractor fails, he can deduct and pay, but no one can ask, he is the prime responsibility to cover the ESI. Next, post, inquiry conducted by IC should be full-fledged inquiry. So we have to follow all the provisions, all the natural justice. That's what Madhya Pradesh High Court also, again it is registering. In these statutory updates or any other doubts you have, you can contact us. You can give your views and under comment box also. Thanks for watching. We will get back to you another good video. Thank you.